A very warm welcome to everyone. Today, I, Reeya Khanna, an intern under LEXIS and Company, am here to give a case analysis on the case Rudul Shah versus State of Bihar. The case is concerned between the two parties named as Rudul Shah versus State of Bihar and another's. The citation for this case is All India Record 1983, Supreme Court 1086. The bench for this particular case was headed by Honorable Justice B.Y. Chandrachud, Chief Justice, Honorable Justice A.N. Sain, and Honorable Justice R.B. Mishra. The issues in this particular case is can prayer for compensation be accepted by the court under Article 32 of the Indian Constitution? The statutes for this particular case involves Constitution of India, Article 32, scope of whether in a habeas corpus petition under Article 32, Supreme Court can grant compensation for deprivation of a fundamental right, and Constitution of India, Article 21, scope whether covers the right to compensation for its violation. The order or decree passed in this particular case was, in the circumstances of the instant case, the refusal to pass an order of compensation in favor of the petitioner will be doing mere lip service to his fundamental right to liberty, which the state government has so grossly violated. Therefore, as an interim measure, the state must pay the petitioner a further sum of rupees 30,000 in addition to the sum of rupees 5,000 already paid by it. This order will not preclude the petitioner from bringing a suit to recover appropriate damages from the state and its erring officials. The head note for this particular case is the petitioner, who was detained in prison for over 14 years after his acquittal, filed a habeas corpus petition under Article 32 of the Constitution, praying for his release on the ground that his detention in jail was unlawful. He also asked for certain other reliefs, including compensation for his illegal detention. When the petitioner came up for hearing, the court was informed by the respondent state that the petitioner had already been released from the jail. The facts of this particular case are that the petitioner's detention in the prison after his acquittal was wholly unjustified. Article 32 confers the power on the Supreme Court to issue directions or orders or appropriate writs for the enforcement of any of the rights conferred by Part 3 of the Constitution. Article 21, which guarantees the right to life and liberty, will be denuded of its significant content if the power of this court were limited to passing orders of release from illegal detention. One of the telling ways in which the violation of that right can reasonably be prevented and due compliance with the mandate of Article 21 secured, it is a violator in the payment of monetary compensation. The right to compensation is some palliative for the unlawful acts of instrumentalities which acts in the name of public interest and which presents for their protection the power of the state as a shield. Respect for the rights of individuals is true bastion of democracy. Therefore, the state must repair the damages done by its officers to their rights. Now, the ratio was Rudul Shah's case is a landmark judgment in the jurisprudence of state liability. It is considered particularly important as it led to the emergence of compensatory jurisprudence for the violation of fundamental rights under the Constitution. It is noteworthy in the context that there is no express provision for awarding compensation in the text of Indian Constitution, and this judgment was on the basis of court's interpretation of the extent of its remedial powers. This was the first case since the inception of Supreme Court that awarded monetary compensation to a person for the violation of his fundamental rights guaranteed under the Constitution. The grant of such monetary compensation was in addition and not to the exclusion to the right of the aggrieved person to bring an action for damages in civil law or in tort. The jailer's affidavit leaves much to be desired. It narrates with an air of candidness what is notorious, for example, that the petitioner was not released from the jail upon his acquittal and that he was reported to be insane. But it discloses no data on the basis of which he was adjudged insane, the specific measures taken to cure him of the affliction, and what is more important, whether it took 14 years to set right his mental imbalance. No medical opinion is produced in support for the diagnosis that he was insane, nor indeed it is any jail record produced to show what kind of medical treatment was prescribed for and administered to him and for how long. The letter number 1838, dated May 10, 1974, which, according to paragraph 3 of the affidavit, was sent to the Law Department by the Superintendent of Central Jail, Muzaffarpur, is not produced. There is nothing to show that the petitioner was found insane on the very date of his acquittal, and if he was insane on the date of acquittal, he could not have been tried at all, for the simple reason that an insane person cannot enter upon his defense. Thank you.